Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning the case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the offense. Felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is the minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without a possibility of parole or death by lethal injection. Now, you don't have to worry about those type of punishment because, as I mentioned to you earlier, your case is a misdemeanor case. And misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, if a person is convicted of a Class C misdemeanors start in the city court or the JP court. And they come to this court when a person is convicted in one of those courts and they appeal their case. And appeal is, well, they want to have a new trial. And their case gets appealed to this court and they get a new trial. Now, the range of punishment stays the same. And the range of punishment for a Class C misdemeanor is fine only. They cannot be given jail time, and a fine cannot exceed $500. Example of a Class C misdemeanor is not having your seatbelt on, speeding, running a red light, having expired license sticker, a license, or having expired inspection sticker. Those are Class C misdemeanors. Now, if a person fails to pay the fine, then the court can issue what is called a capious pro fine. A capious pro fine is just a warrant for their arrest for them either to pay the fine or sit the fine out in jail. And if they sit the fine out in jail, they'll be credited at $100 per day for every day that they sit in jail, and it will go toward their fine and court costs. Now, if the fine was converted to community service, they failed to perform the community service, then the court can also issue a capious pro fine, and they can sit the fine out or the time out in jail. Okay, now the next highest misdemeanor, we had a Class C misdemeanor, now the next highest was a Class B. With the Class B misdemeanor, the range of punishment is 0 days to 180 days, which is 6 months in the county jail. Or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. The range of punishment for Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such jail time and a fine. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation, we normally refer to as deferred adjudication. And what that means is you don't have a conviction on your record when you get on the probation. And if you successfully complete the probation, you will not have a conviction on your record. And you can get what is called, you won't have a conviction, case will be dismissed, and you can get what is called a non-disclosure. What a non-disclosure basically means is that your record is sealed to the general public. So the general public cannot have access to the case that you receive unadjudicated probation on. So for example, let's say you applied for a job at ExxonMobil and you had your record, you had a non-disclosure. Your record is sealed. They do a criminal background check on you. They can't see it. Why? Because your record is sealed. Okay? Now, however, if you get a subsequent conviction is another conviction later on, then the case that you received deferred adjudication on, it can be brought back up. It can be resurrected. It can be revived. And if you try to get a license with Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend the license. Now, the next type of probation is called adjudicated probation. We have unadjudicated probation, and the other type is adjudicated probation. We kind of refer to it as regular probation. With the adjudicated probation or regular probation, it does result in a conviction on your record. However, there is something that is called judicial clemency, where the judge or the court can set your conviction aside. In essence, you will no longer have a conviction. In order to qualify, three things has to happen. One, you have to successfully complete the probation. Two, there cannot be any more time left on the probation. And three, the probation office has to successfully discharge you off the probation. If those three things happen, then the court has the discretion to set your conviction aside, and you will no longer have a conviction on this case. Okay. Now, everyone here for a case, you should have a clipboard. Who does not have a clipboard? Okay, hold on a minute. Are there any clipboards out there? Yes, one's right there. Okay, could you get that one to me? Okay. You need one?
No.
Okay, okay. Now, the reason why I asked if everyone had a clipboard, because I'm getting ready to go over the paperwork that's on the clipboard. Okay, and everyone is going to make a choice on that first document. Should be the long document. It should be judge's explanation of rights to defendants without attorney, and it should look like this. Okay, document looks like this. This document states that as a defendant in a criminal case, you have three options. And it states the option. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, the first sentence below number three states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. The next one sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request or you may ask the court to appoint an attorney to represent you, but you must first fill out a financial questionnaire. You will fill that out so that the proper person will determine or can determine that you qualify for a court-appointed attorney. Now, The financial questionnaire is a 3-page document that is also on the clipboard. Now, before I go any further, the only people that will fill out this financial questionnaire is individuals who will be applying for a court-appointed attorney. If you are not applying for a court-appointed attorney, don't worry about this document. But if you're applying for a court-appointed attorney, the first thing that you would have to do is fill out the first page, and it's titled Jackson County Affidavit of Insurance or Affidavit of Insurance. You fill out the first page, and then you go to the second page, and at the top of the second page, it says Defendant's Oath. Okay, you see that page? You will fill out that portion at the top that says Defendant's Oath, up at the top, and then you go to the middle section that's titled Unsworn Declaration by Defendant. Unsworn Declaration by Defendant. You will fill this out and then you'll stop. Okay. Now going back to the first document. That third sentence is for people who will be representing themselves. Now, if you're representing yourself, that means that you're waiving your right to have an attorney to represent you. You will be representing yourself, which means that you are your own attorney. Okay? And just like an attorney can talk to the district attorney or assistant district attorneys, we have two of them here, you'll be able to talk to the assistant district attorneys as well. Why? Because you are your own attorney. Okay? Now, you can talk to them to see if you can work out a settlement on your case. A settlement is something that we call a plea bargain agreement. In essence, they will make an offer. You can accept it or reject it, but you'll have an opportunity to talk to one of the prosecutors here today. Now, but before you are able to do that, you must first fill out a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding Trial. This is only for people who will be representing themselves. If you are not representing yourself, you don't have to worry about it. But for those people who are representing themselves, you have to read and sign this document and date it, and then you'll stop. Now, let's go back to that first document. In this first document, there is a paragraph in block form. This is for people who will be representing themselves. And it says that beware that the dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you are representing yourself, the last sentence here states that you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you're representing yourself, and let's say you talk to one of the prosecutors. You would like to see if you can settle your case by getting probation. And the prosecutors say, well, okay, we'll give you probation. Or the prosecutors say, well, I'm not offering probation, I'm offering jail time. Well, you can say, well, Judge, I take back my plea. I do not want to enter a plea of guilty or no contest in this case, and I want to apply for a court-appointed attorney. You can do that. You can change your mind. Now, what I should mention is that you have an option to enter one of three types of pleas, and I'll explain that too. You can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting the charges. Okay? Now, at the bottom of this document, everybody's gonna make, you see 5 lines to the left at the bottom. Everybody here is gonna make one choice. It states before that defendant's choice, mark initials next to only one choice. So for those individuals who like to hire their own attorney, place your initials on the first line to the left and sign at the bottom where it says defendant and dated today's date, which is February 3rd. And then you stop. This is the only form you have to sign. If you have already been appointed a court-appointed attorney, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. And then you sign your name and dated today's date, and then you'll stop. This is the only form you would have to sign. Now, if you would like to apply for a court-appointed attorney, you'll place your initials on the third line to the left. Sign at the bottom, dated today's date, and then you would have to fill out the document that is titled Jefferson County Affidavit of Indigence. You fill out the first page, the top portion of the second page, that's titled Defendant's Oath. It should be in a little bracket. You'll see a little bracket on the left side where it says Defendant's Oath. You fill that out. And then you'll also fill out where it says unsworn declaration by defendant. Should be right here. And then you'll stop. Okay? Now, if you, going back to this first form, if you have already been appointed a court-appointed attorney in your case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. Then you will sign, date it, and stop. And this is the only form that you would have to sign. Now, if you would like to waive your right to an attorney, that is, give up your right to have an attorney and represent yourself, then you'll place your initials on the fifth line, which is the bottom line, the fifth line to the left, sign your name, date it, and then you would have to fill out this form that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. Okay, do you have any questions?
No, sir.
Yes.
I filled out the paperwork for a court-appointed attorney whenever I was in jail, and they told me I was approved, so do I still fill it out?
You can fill one out. We would have to check to see if we have that paperwork in your file. Sometimes they send it, sometimes they don't.
I have a question. I ain't got to put down here, but just, his name, Patrick. His name, the attorney,
Oh,
James Patrick.
James Patrick. Well, he's not a court appointed. He's not on our court appointed list.
They come to, can you look and see?
But no, he is a private attorney. He's not on our list. I know all of the attorneys on the list. If you want a court appointed attorney, he's not, he won't be one that's appointed.
Okay, that's,
You have to hire him.
yeah, that's fine. With just counting something to my house.
Okay.
I was it.
No,
Okay,
yeah,
that's fine.
We wanna waive our right, and we can just taken care of today.
yeah, it'll be taken care of later. Okay,
I was the notice of if I can look and translate for him since he was.
okay, we have a translator. And we can get our translator in here, yes.
So, if I waive my right and choose to still represent and I speak with the AADA and I change my mind, I can do all it in one day until like change my mind.
Yeah.
Until you get out and get a lawyer.
Yeah,
Okay.
okay. Anybody else?
No.
Okay, now, the next thing that I need to go over, we're gonna give you a chance to fill out that paperwork. All right, now the next thing I need to go over, is your right to, have a jury trial. Okay? Well, first of all, I went over, you could enter a plea of guilty. If you enter a plea of guilty, tell the court that you committed the offense that you've been charged, you can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or if you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting the charge. Now, if you enter a plea of guilty or no contest, and if you decide that, you would like to settle the case, obviously that will be taken care of. Then you'll have an opportunity to talk to one of the prosecutors. Now, you have a right to have a jury trial. If you enter a plea of not guilty, say you want to have a jury trial, you have a right to have a jury trial. When a young man is sitting, Chris, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all the evidence. That is, they'll listen to what the state is presenting. They'll listen to the defense. They will listen to the arguments of the state, arguments of the defense. They will go back into the jury room to deliberate, and then they will decide whether or not to find you not guilty or guilty. You also have a right to waive or give up your right to have a jury trial. If you're waiving or giving up your right to have a jury trial, that simply means that you will not be having a jury trial. However, you still can have a trial. You will have a trial, we call it a bench trial. It will be a trial by the judge. The judge will be the judge and the jury in the case. The judge, and the reason why we call it a bench trial, because the judge sits on the bench. Okay, so the judge will listen to all of the evidence that's presented by the state, the defense. The judge will listen to the arguments of the state and the defense. The judge will apply the facts to the law, and the judge will decide to find you not guilty or guilty. Now, you can waive or give a right to even have a trial by jury or judge, and well, you can enter a plea of guilty or no contest. Okay, now you'll have a right, as I mentioned to you earlier, to talk to the state to see whether or not you can work out a plea bargain agreement. Now, if you are able to work out a plea bargain agreement, we call that an agreed plea. You agreed to it. And agreed, we'll come to agreed plea bargain agreement. Then it goes before the judge. The judge can do one of two things. The judge can accept or reject the plea bargain agreement. So if the judge rejects your plea bargain agreement, you can take your plea back. In essence, you can tell the court that, well, since you're not accepting the plea bargain agreement that I've worked out with the state, I take my plea back. So I'm withdrawing my plea of guilty or no contest. You can do that. Now, if the judge does follow the plea bargain agreement, and if you decide within 30 days, the reason why I'm saying 30 days, because within 30 days, you have the option to file an appeal, request a new trial. And if you decide that you'd like to file an appeal, you have to get permission from the judge that followed the plea bargain agreement. If the judge gives you permission, then your case is going to leave this court. It will go to the Ninth Court of Appeals. There are 4 judges on the Ninth Court of Appeals. They will review your case. Actually, the Ninth Court of Appeals is right above this court on the 3rd floor. They will review your case. They will see whether or not you've been wrongfully convicted or whether or not this court committed an error. They can do one of 2 things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Or they can send the case back down to this court, or the court to give you a whole new case, a whole new trial. If they deny your appeal, guess what? You can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your case to the highest criminal court in the state of Texas, and it is called the Texas Court of Criminal Appeals, located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. I'll explain that to you. Pro se means self. In essence, I'm representing myself. And I'm petitioning or asking the court, the Texas Court of Criminal Appeals, to review my case to see whether or not the Ninth Court of Appeals should have granted my appeal, or whether this court wrongfully convicted me, or the court committed an error by convicting. Okay? And so that will be a pro se petition for discretionary review. Now, they can do one of 2 things. They can grant it. If they grant it, they can simply find you guilty. Case over. Or they can send it back to the Ninth Court of Appeals with orders, or back to this court with orders. Now, if they deny it, then at that point, your conviction will stand. Now, The other right that you have is a right to have what is called a a right to have witnesses come to court. That chair that has the microphone in front of it, we call that the witness stand. And witnesses can testify for you, against you. And you have a right to call witnesses. Now, you can waive or give up the right to call witnesses. If you waive or give up the right to call witnesses, that means you will not be calling witnesses. Does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. You also have what is called a Fifth Amendment right against self-incrimination. I'll explain that to you. The Fifth Amendment of the United States Constitution gives you the right, or gives us the right, to remain silent. That is, not to say anything in our case. The state, the government, the district attorney's office cannot force you to take the witness stand and testify against yourself. And if you think about it, it makes sense. And the reason why it makes sense is because the state district attorney's office, they have the burden of proof. What that means is they have the duty to prove you guilty beyond a reasonable doubt. You don't have to prove yourself guilty. They have to prove that you're guilty, okay? And so if you invoke your Fifth Amendment right, or you exercise your Fifth Amendment right against self-incrimination, they cannot force you to take the witness stand. So I know a lot of us, we watch television, and we might see on one of these law and order shows where the television lawyer will go up to the witness stand and ask the witness a question, and the witness say, "I take the fifth." And that means he can't testify. He's not saying anything. You can't ask him to say anything, okay? Because he's exercising his Fifth Amendment right against self-incrimination. Now, you also have a right to have what is called discovery. Now, discovery means that you have a right to see the evidence that in the state's file. So, for example, you have a right to see your statements, witness statements, police reports, lab reports, video recordings, photos. You have a right to listen to audio recordings, a right to have access to documents or instruments, anything that they have as evidence in the case. You have a right to have access to that. Now, you can waive or give up your right to discovery. And if you do, that means that you will not be having access to that information. Now, everyone that's here for a case, you've been charged, arrested, you've been placed in jail, you're out of jail on a bond. That is, you're out of jail on a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you pay a bondsman a percentage of the bond to get out of jail. Or you're out of jail on a PR bond or personal recognizance bond, which means that you do not have to pay any money to get out of jail. You were released on your own personal recognizance. Now, I've said that to say this. Every day that you spent in jail can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail. And let's say you talked to the prosecutor, your lawyer talked to the prosecutor, and they're offering that you serve 5 days in jail. That means you don't have to serve any more time in jail. Why? Because you already served 5 days in jail. So you'll be given credit for time served. Okay, now, if they're offering 7 days in jail, you serve 5, that only means you have to serve 2 more days in jail. Because we'll take 5 from the 7, that leaves 2. Now, every day that you spent in jail can also be used towards your fine and court costs. You will be given $100 credit for every 1 day that you spent in jail. So, if you spent 5 days in jail, that's $500 credit. Yeah, it can go towards your fine and court costs. If the state is offering you fine and court costs of $500, that means you don't have to pay anything. Why? Because the time that you have spent in jail has already paid it off. So therefore, the fine and court costs will be what we call taxed and retired. Now, if the state is offering fine and court costs of $700, you spent 5 days in jail, which is $500, then that means you only have to pay $200. Why? Because you already have $500. We're going to take the $500 from the $700, that leaves $200. All right. Now, you'll be required to pay the fine and court costs on the day that your case is disposed. If you can't pay it, no problem. We can put you on what is called a payment plan, where you can pay it off in small monthly installments. Now, If you don't have the income to pay it off on a payment plan, no problem. We can convert the fine and court costs to community service. Now, for every 1 hour of community service that you perform in a nonprofit organization, $12.50 will be credited toward your fine and court costs. So, using that example, say you owe $200, right? If you work 8 hours, guess what? That's $100. You work 2 8-hour days, that's $200, and then guess what? You paid off your fine and court costs. Okay? So as you get like $12.50 an hour. So that's what happens. Okay, now Jefferson County has a program. The program is for first time offenders. Like, for example, if you haven't had charges filed on you before, it's your first time getting in trouble with the law, Jefferson County has a program where they will dismiss your case and you can get it wiped off your record. The program is called pretrial diversion. With the pretrial diversion, what they would do is you get into the program, they would dismiss the case, you complete the program, you can get it, the case expunged from your record. Expunged means wiped off, deleted, or erased from the record. They just call it expunged. Okay? So it's like it never happened. In order to qualify, 3 things has to happen. 1, you have to have a lawyer to help you with the application process. Now, the lawyer could be a court-appointed lawyer. Don't have to be somebody hired. The next thing, it cannot be for an offense involving unlawful carrying a weapon or resisting arrest. And the third thing is, again, you have to be your first time getting in trouble with the law. Those 3 things have to get in the program, they dismiss the case, then they can, when you complete the program, you can get it expunged, which means erased, deleted, or wiped off from there. All right. Now, Jefferson County District Attorney's Office has another program for veterans. That program is called Veterans Court. If you're a veteran of any one of the branches of the United States military, then with that program, once you get in the program and complete the program, they'll dismiss the case. And then you can get what is called a non-disclosure where your record is sealed to the general public. That means that the general public cannot have access to it. Now, the operative word is general public because certain government agencies can. But the general public is most of the public, they can't have access to it. Okay. Now, this court, County Court at Law Number 2, Jefferson County, Texas, has a program. The program is a program that God led me to start in the first 100 days of taking office in March of 2017. The program is the Community Safety Initiative. It's an acronym, CSI. The CSI program stands for Community Safety Initiative. With that program, the program is designed to address the issue of what we call recidivism. I'll explain that to you. Recidivism means when people commit crimes over and over, reoccurring, continue to commit crime. And so the program is designed to address that. And the way we address it is through partnerships that we have with various agencies in our community. One of the agencies that we have a partnership with is the Spindletop Center. We have someone from the Spindletop Center will come here, well, he's here, and he'll tell you a little bit more about the program. But basically, what Spindletop Center is our local mental health facility in the Southeast Texas region. And they have the expertise to address mental health issues. Now, in order to participate in the program, you do not have to be incompetent or insane. You could just merely suffer from depression or anxiety or any other host of mental illness, and then they have the expertise to address those issues. If you have issues with drugs or alcohol, Spindletop has a program that is called ATAR. ATAR is an acronym that stands for Addiction, Treatment, and Recovery. We also have a program with our local drug and alcohol council that has a program that is called OSAR. OSAR is an acronym, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do is to give you a screening. They will do an assessment, and they will develop a treatment plan for either outpatient or inpatient treatment. Now, the Spindletop mental health program, what they will do, they can conduct a private interview, either in our jury room, at their facilities, by telephone, whichever is convenient for you. They will do an assessment to determine what the mental health issue is. And then they'll develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, which is a partnership with Lamar University. And Lamar University has a program that is called CICE. It's an acronym that stands for Center, Innovation, Commercialization, and Entrepreneurship. It's a job training program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas that you select, they will help you to get a job in the area that you're trained in. And the beauty of that program is, for example, a lot of times people may be trained in different areas, and because of their background, they may go and apply for the job. They don't get the job, right? They go through that program, go to the same place, right? They will go to the place for you, they get the job. So that's the beauty of being in that program. The other thing is, if you have not graduated from high school, or if you do not have a GED, they have a program where you can get your GED or your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost anything but time. And I like to say in this school, we don't just give time. We take our time.
Come on now.
And the reason why we take our time is because we don't want to just arrest the problem. We want to address the problem.
Right.
And we believe that if we address the problem, we can produce productive people.
Yeah.
And if we produce productive people will not commit crimes. Why? Because they had too much to lose. So I like to say, when you come to County Court at Law Number 2 of Jefferson County, Texas, we don't just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, we can give you the brochures and direct you to the people that you need to talk to so that you can get on the road to living your best life. So at this time, we have our mental health deputy, Deputy Powell. He is with Spindletop and Jefferson County Sheriff's Office. He's going to tell you just a little bit more about the program that Spindletop has to offer.
Y'all stressing today?
It's red.
Don't stress. Everything's fine.
It's sleeping.
Hungry.
Hungry, sleeping.
Yeah.
Yeah, we got that. So, normally I have a qualified mental professional. They left me strange today. So I'm gonna do the best I can to. So you're asking yourself, why is the police do it? 9 years ago, we decided to park in a simple top and have those guys right along with us, like park. They go, we go. You go, we lie, vice versa, one that we eat together. We pay for it together, we do everything. So what we learned is that sometimes we'll understand what you're saying. So if you have a part-time professional with us, to respond to a crisis, work both together, it comes out You know, I want more savings for everybody. Like, so the judge mentioned, about our program. Now I'll hand you a piece of paper out. That you can fill out, if you need some of our services. You don't have to have a mental health problem or whatever, we deal with all kinds of stuff, with jobs and stuff, abuse and. You know, there's all kinds of stuff that's out there for you, qualify for the service. Right, that's why I'm asking you to speak to paper, do you want contact? You want one of us to contact you? All right, feel free to put that down. Right? I'll say face to face, I can't do face to face unless I have my cue, because we call them cue. I won't sit down and talk with you today. But when she gets back tomorrow, she'll make contact with you by phone, email, or via text on. I mean, I won't handle it. Right?
Is this been for you?
So it may be on
Try
there.
to put it out, put it out there.
Is it already on your thing?
Yes,
Yeah, definitely.
I feel around that.
Yeah,
I'm
that's.
not from there, the person who's not.
Again, you don't have to fill it out, and then it's on mandatory to fill out. So,
Who give me you?
yeah, I'll pick them
We,
up.
we'll pick them up when you pick up your paperwork.
Okay, thanks.
Thank you.
Oh, it's gonna be in, you got your other one? You have your other one? Yeah. All right.
Thanks a lot, Dan. At this time, we have a gentleman, by the name of Chris, Spady. He is gonna tell you about the program that they have for veterans. He's here for the first time, so he'll just tell you a little bit more about the program that, Stone River has to offer.
Hi, everybody. My name is Chris Fahey. I'm a Navy combat veteran, served 18 years, 5 deployments, spent a year in Afghanistan. Because it's so sweet. I love Texas, man. California, I like this. And, before that, my mother had taught me really what trauma was. I grew up in a very low income house. She was out doing whatever she could do for money. Dad was gone. And I didn't really understand what trauma looked like in my life. I thought it had to be kinetic. I thought it was with a weapon in your hand, facing an enemy. And what I didn't realize is that's not what trauma is at all. It's a form of it. The trauma can be anything. Trauma can be anything that has stress and environmental hazards associated with it. And if it's the right amount of stress and the right hazard, it's going to shut you down. You're going to respond to the world very differently. High risk behaviors aren't going to be so scary anymore. Your connection with yourself is going to be damaged. Your connection with the outside world, your ability to maintain healthy relationships. That's what trauma does. It destroys all of that. That's when drug abuse, substance use, alcohol should become very easy because we're self-medicating against those feelings, or lack of feeling. And we all make a bunch of choices in those moments that we regret. I certainly did. I was popped with possession 2 years after I got out of the Navy. Spent some time in Montgomery County Jail, and that's when I was really learning what trauma was doing to my body, my mind. Stone River is a trauma treatment center. There's only 5 of them maybe in the entire state. And we just happen to have one in San Antonio. I work with Houston, and that's the closest to Jefferson County you're gonna find. I'm the military veteran outreach coordinator, but it's for all adults. If you have commercial insurance, we're in network with those. If you don't, but you're a veteran and you have VA benefits, I can help with those. And even if you don't have any of those, I can still work with some community partners to find some form of help. But I think now that I'm kind of learning how the court operates, what I would probably like to do is anybody who signed one of those lead forms in order to kind of get some help with Spindletop, I'm just gonna make sure that they have a bunch of these and they have my card. And if you'd like to talk about trauma, if you'd like to talk about substance use, if you'd like to talk about mental health rehab, we can do all that. We're a luxury facility. We can bring service animals. We have a salon for women to get their hair done. We have a barber shop for men to get cleaned up. We believe in self-care. We believe in love. But ultimately what we're trying to do is dive down into this cognitive process, some never-ending loop that might be going off in your brain that tells you you're unworthy. It tells you you don't have any value. It tells you that you're not good enough and that everything that you do is going to be okay because who cares, right? And we want to find that and reprogram it so that instead of feeling shame and guilt and building a foundation of choices on those two emotions, we can replace it with self-compassion and self-love to have a new foundation to make more positive choices. It is honestly a very simple process. It takes a god awful amount of work, But at the end of it, I know I came out a much better person and I learned to love myself. When I was able to love myself a little better, I was able to make a lot of happier choices. And I never found myself with a wall again, thankfully, and I have to work with them, which is amazing. They still kind of scare me. I'm not gonna lie to you. See a man with a gun on his hip, and still like, why does he gotta be here? And but I've got all of these, which tells you a lot about our approach to trauma and what you can experience when you're there. A beautiful place to find healing. We have an excellent can never say that word, recidivism rate. People who go through our program usually don't come back. They see some form of long-term help, and we don't just bring you in for a program and let you back out. We got our hands wrapped around you for a year. So every week for a year, we're checking in with you. It would be me if you came through me. And we're tying you into all different levels of care that are all already assigned to your insurance. We do all that vet work. So the only money that you actually pay is what you just owe in your insurance for your out of pocket. We're in network, we're not out of network, which means there's no outside costs that come up and sneak up on you or surprise you. You know exactly what's going on, and once that's taken care of, we can walk you through the elements of care for that next year, and really help people. My calling in life, much like these gentlemen, is to affect positive change. And I think first that started with me and my relationship to God. And then after that, it's finding you and your relationship to God and yourself. So that's what I want to help with. We're not spiritual by any means, we're not God driven, but I think God is everywhere, right? So you'll find it here too.
All right, thanks a lot, Chris. Okay, now, ladies and gentlemen, we're gonna give you a chance, to finish filling out the paperwork. If you need help filling out the paperwork, we have our core personnel, including myself, who will be happy to help you to fill out the paperwork. Now, we're gonna pick up that paperwork from you. And then we're gonna put you into one of three categories. One category is, you wanna hire your own attorney. And, once we go up there, you wanna hire your attorney, your case will be reset today. You will be given another court date to give you time to hire your attorney. If you apply for a court-appointed attorney, if you qualify, you will be appointed a court-appointed attorney the day before you leave. If you would like to represent yourself, you'll have an opportunity to talk to the prosecutor. And if you are able to come to a plea bargaining agreement, your case will be taken care of today before you leave. All right. Now, please be mindful, one, that you're still in court. If you need to use the restroom, there are two restrooms right out in the halls. There's the men's restroom in front of County Court at number 3, and on the opposite side of the hall, there's a women's restroom in front of the 172nd District Court. Now, you'll be allowed to go out and use your restrooms. Please do not leave the courthouse. If you leave the courthouse, and when we get to your case, your name is called, you're not here, a warrant is gonna be issued for your arrest. You'll be arrested, placed in jail, you're gonna have to bond out of jail again, and guess what? We're gonna have to go through this all over again. And so, in order to save us time, just be mindful, make sure we conduct yourself accordingly, you're still in court. Oh, at the top, yeah, he already did it. Yeah. At the top of that document, there's judge's explanation, it has a line, you print your name on that line. I forgot to mention that to you, okay? Now, you're gonna take up the forms, from you, if you need help, just raise your hand, and we'll be, she's gonna help as well. They're gonna come out and get the, form from you, okay? Okay, so we'll be in recess.
Great.
When I call your name, please come before the bench. Alexander Wilson. Mr. Wilson, your full name is Alexander Wilson. Mr. Wilson, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Wilson, you may put your hand down. How are you doing, Mr. Wilson?
Yes.
That's good. Can't be better than being blessed. Mr. Wilson, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yeah.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you would like to hire your own attorney?
Yeah, that's me.
And Mr. Wilson, before you sign and initial this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Wilson, Ms. Mosby. Okay, Mr. Wilson, your case is gonna be reset, but before the bailiff give you, the court coordinator give you the reset, I need to go over some bond conditions with you. The document that you was handed is titled Standard Bond Conditions in County Court at Law Number 2. And it states, following return of a criminal information in County Court at Law Number 2, Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Look for his next case. Hold on a minute. Did you already move it? Oh, no.
Yes, I do.
Because I was looking. Oh, here it is. Never mind.
It should still be on.
It is. Also, condition number 2 states that the defendant shall submit to testing for drugs and alcohol at any time
Understand.
as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? And condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and that person name is Alexa Wilson.
Yeah.
And you shall not go near any residence, school, or other location frequented by the alleged victim.
Yeah.
Do you understand that?
I got good, yeah, but I ended up living, staying with the beach into this.
Okay, so you understand that condition?
Yeah. Yeah, I found what up to.
Okay. Now, condition number 4 does not apply. Condition number 5 does apply. Condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Okay, now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Okay. Now, have a seat in that first chair on the wall. Wait for your name to be called by the coordinator. Oh, okay. You have your reset. Once you get your reset, you're free to go and you have a blessed day.
That's it.
Miss Araji. Jefferson County Court at Law number 2 is back in session. The court is in session in cause numbers 25 CCCR 2180 and cause number 25 CCCR 2203. Both cases are styled the state of Texas versus Javier H. Arthur. Mr. Arthur speaks Spanish. We have our translator, Ms. Jennifer Araji. Ms. Araji, would you please raise your right hand? Do you swear to interpret English to Spanish and Spanish to English to help you God?
Yes, sir.
Okay. You may put your hand down. How are you doing, Ms. Araji?
Good job.
That's good. And Ms. Araji, ask Mr. Arthur if his full name is Javier H. Arthur. I think it's Javier Hernandez Arthur.
Yes, Judge.
Okay. Ask Mr. Arthur to raise his right hand. Mr. Arthur, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Judge.
Okay. Mr. Arthur, you may put your hand down. ¿Cómo está?
Bien.
Bien, that's good. Now, Mr. Arthur, I have before me a document that is titled, well, he has a document. You have a document before you that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize that document?
Sure. Yes, Judge.
And are those your initials on the line that state you would like to hire your own attorney?
Yes, Judge.
And did you sign that document?
Yes,
Okay.
Judge.
The other document, well, now, before you signed and initialed that document, did Mr. Raji go over that document with you in Spanish?
Yes,
And did you understand everything that she went over?
yes, Judge.
Okay. Now, your case is going to be reset to give you time to hire your own attorney. Okay. Now, you also have been handed a document that is titled Standard Bond Conditions. And did Mr. Raji go over these conditions, which is in particular conditions 1, 2, and 5? And did you understand everything that she went over with you in Spanish?
Yes, Judge.
And if you violate any one of these conditions, your bond can be revoked. And you can be arrested and placed in the Jefferson County Jail. Okay, do you understand? Okay, stand before the court coordinator, get you reset. Once you get you reset, you'll be free to go and you have a blessed day. And you have a blessed day as well, Ms.
Thank you,
Williams.
Judge.
Thank you.
You just want me to get this done. Oh, yeah. You could tell me. Okay.
The Nika ballot. The Nika ballot,
Yeah. Mira, you got it, you can do it. Come on. You put it in.
Mr. Ballard, your full name is that Danica?
Yes, sir.
How are you doing?
Fine, you?
I'm doing fine. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? You may put your hand down. Now, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? Or are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
Also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this document, there is a signature above the line that's titled defendant signature. Is this your signature?
Yes, sir.
Now, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Ballard, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in this case is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. But before she gives you that information, I need to give you some bond conditions. Please stand to, you can get these bond conditions, and then you can stand back in front of the bench. Now, I'm going to go over these conditions with you. And it states, standard bond conditions in County Court at Law Number 2. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
And condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? And condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim in this case. And the alleged victim is Alicia Mansell. Do you understand that?
Yes, sir.
So it states that you cannot communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Sir.
All right. Condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that?
Yes, sir.
Now, Mr. Ballard, if you violate any one of these conditions, bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County jail. Just have a seat in that first chair, wait for your name to be called. Once your name is called, you go to the window. And once you finish at the window, you'll be free to go and you have a blessed day. Sarah Edgerton. Ms. Edgerton, your full name is Sarah Elizabeth Edgerton. Okay, Ms. Edgerton, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Edgerton, you may put your hand down. How are you doing, Ms. Edgerton? You doing okay? That's good. Now, Ms. Edgerton, you are, I have before me, excuse me, two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for a court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And is this your signature on the line that is titled Defendant?
Yes.
Ms. Edgerton, before you sign and initial these documents that I just showed you, did you read the documents?
Yes.
And did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Edgerton, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in this case is Attorney Langston Adams. Attorney Adams will be given information to contact you. You will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall. You're welcome. And the attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Don Boudreaux will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall and wait for your name to be called.
Thank
You're welcome. Okay. Christopher Nation. Mr. Nation, your full name is Christopher Nation. Mr. Nation, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
So Nation, you may put your hand down. How are you doing, Mr. Nation? I'm doing fine, thanks for asking. Mr. Nation, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states you'd like to apply for court-appointed attorney?
Sure.
And I also have another document. This document is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this document, there's a signature above the line that's titled Defendant Signatures. Is your signature.
Yes, sir.
Now, before you sign and initial these documents, Mr. Nation, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Nation, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Tom Burbank. Attorney Burbank will be given information to contact you, and you will be given information to contact him. And our court coordinator will give you that information. Once you get that information, you'll be free to go. And you have a blessed day.
You do the same.
All right, please have a seat in that chair on the wall. Here you go. This is somebody else. Jasmine Fonnet, all right. This is cause number 25 CCC Aura 2836, case is styled the state of Texas versus Jasmine Fontenette. Ms. Fontenette, is that your full name? Ms. Fontenette, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. And Ms. Fontenette, how are you doing? That's good.
I got somebody, I prayed for. I got
Well, that's good. God hears and answers prayer.
I told him what you had said when you was talking.
Mm-hmm.
I said, you said number, how I go and never go and
That's right. Now, Ms. Fontenette, the state is represented in this case by Attorney Shane Hilton. And Mr. Hilton, how are you doing?
I'm good, Your Honor. Thank you.
That's good. Now, Ms. Fontenette, before we go any further, you have a right to have a record. That is, you have a right to have a court reporter to dictate everything that's being said. You also have a right to waive or give up your right to have a record. Do you waive or give up your right to have a record? Or do you want a record?
Like, Dan, like.
No, you can have this court reporter that's sitting to my left.
Recording.
He can record everything that's being said.
No, you don't have to.
Okay, so you waiving your right to have a record. Now, Ms. Branch. No, that's not it. You got the one. Oh, Fontenette. Okay, Ms. Fontenette.
Huh?
I have before me a document.
Can't tell you that. That's
Okay, no. So.
Okay. Okay, you ready to go forward?
Mhm.
Okay, now, Ms. Fontenette, I have before me a document on paper that's titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes,
defendant?
it is.
And are these your initials?
Yes, sir.
Oh, she just put a check, Miss,
No, that's JF.
no, but she put it in the wrong.
You know I had marked it twice?
I know, let me do this, I'm gonna give her a chance to put her initials in the spot it's supposed to go in. She had a check here. It's the last one.
Yes, sir.
You need a pen? Suppose she's waving her right.
No.
Okay.
This one's not it.
It's the last one, the last. Okay, now, Ms. Fontenette,
Yes, sir.
I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled defendant? And are these your initials on the line that states you like to waive your right to an attorney?
Yes.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
I didn't read it, but.
No, that's just the title.
Okay, yes, sir. That's not-
Is this your signature on the line that's titled defendant?
Yes, sir.
Now, before you sign and initial these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, I did.
And is everything in these documents true and correct
Yes,
to the best of your knowledge?
yes, sir.
And Ms. Fontenette, are you a citizen of the United States?
Yes, sir.
State of States Exhibit 1.
Okay, now, Ms. Fontenette, the state is offering, let me do this here, I didn't even go up there.
Okay.
Okay, Ms. Fontenette, I have before me a document that is titled misdemeanor plea admonishment. This document is also labeled as state's exhibit number. Hold on a minute, I'm getting a little ahead of myself. Before we get to states one. Also, I have before me on my computer right here, a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jasmine Fontenette, on or about August 21st of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest detention. Ms. Fontenette, do you understand what you've been charged with?
Yes, sir.
To this charge, how do you plead guilty, not guilty, or no contest?
No contest, not true.
No contest. So are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means. Okay. I also have another document that is titled misdemeanor plea admonishment, also labeled as State's Exhibit Number 1. Do you recognize this document? On page,
I know what you're saying.
oh, it just slid, okay.
Yeah.
On page 2 of this document, there are 2 sets of initials.
I did.
The first set of initials is on a line next to a box that check no contest, which means, but set no contendere, which means no contest. The second set of initials, they're on a line that state, I do not request discovery in this case, and I waive my right to discovery. Did you place your initials on this? Okay. On page 3 of this same document, there's a signature above the line that's tied to defendant. Is this your signature? And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Ms. Fontenette, before you signed and initialed all of these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
I read them all.
And is everything in these documents true and correct?
He read.
Okay. And is everything in these documents true and correct to the best of your knowledge?
Yeah.
And now the state is offering State's Exhibit Number 1 into evidence. State's Exhibit Number 1 is the first document that I showed you on the tablet. That's this document. This is the same document that have your initials in these 2 locations. And it has your signature in this location. Is it all right for the state to use this document as evidence in your case? Okay, no objection. State's Exhibit Number 1 will be admitted. And Ms. Fontenette, is there any evidence that you are currently mentally incompetent to stand trial? Yeah.
And company?
Okay, there's no evidence to that.
I have a withdrawal.
Okay,
I'm not planning on coming back to you.
I understand it.
I told
So,
you
Ms.
earlier.
Ms. Fontenette, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 32 days county jail with credit for time served of 32 days. And we'd ask that the court costs in this matter be taxed and retired.
Okay, let's find that the state is offering that you serve 32 days in Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail because you've already served 32 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. Now, the court costs in this case will be taxed and retired. That simply means that you would not have to pay it because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Fontenette, do you understand the state's offer?
Yes,
Do you think that is fair and just?
Yeah, we can answer this question.
And, hold on, no, you accept the state software?
Yes, do.
Okay,
Yes, sir.
I'll follow the plea bargaining agreement that you have entered into with the state. What's your question?
You said, I was talking about my brother back there, like the minister, come back. What do I get? Who gives that?
What are you talking about?
The, what's it called again?
Your bond?
Yeah.
If you have a
Yeah,
cash
your
bond,
bond.
if you have a cash bond, then you get that back from the county clerk's office
Okay.
downstairs.
So,
Okay. If it's a surety bond, which means if you had a bondsman, you don't get it back.
mhm.
That's not a cash bond.
You don't get any money back.
That's not that.
You see the first one or twice?
You what, baby?
She said she went twice. You might have had a bond forfeited. I don't know.
Yeah, one was for a felony.
Oh, a felony.
I think so. Is that what you were telling me?
This, no. No.
I'm just showing you post up.
Let me do me.
Okay, once you stand, you can stand over there and she can look for it.
Okay.
Okay,
I'm just showing professional here.
Yeah, I have one about twice with patient and one with allied. You don't see allied? No, we.
Even if you had it outlined, that's a bonding company.
Henry Moore.
You're at the jail. You're not getting anything back. That's a bonding company.
That's a surety bond. That's not a cash bond. Surety means you have a bondsman.
Is this one? Most, that's what she's gonna need. Okay.
There's not something wrong. That's the thing.
Um,
That's the thing, that's the one.
Jefferson County Court of Law number 2 is back in session. Court is in session. In cause number 25 CCC 2484. Case is styled of State of Texas versus Henry Dwight Moore. Mr. Moore, is that your full name?
Yeah.
Mr. Moore, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Moore, you may put your hand down. How are you doing, Mr. Moore?
Hmm.
That's good, Mr. Moore. I have before me, well, we have Assistant Criminal District Attorney Cornelius Williams. He's Assistant Criminal District Attorney for Jefferson County. And Mr. Williams, how are you doing?
I'm doing well, Mom, thank you.
That's good. And Mr. Moore, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir, that's my signature.
And is this your signature on the line that's titled defendant?
Yeah.
And are these your initials on the line state you'd like to represent yourself? I also have another document that is titled Waiver of Counsel for Purpose of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this
Yes.
document? Is this your signature on the line that's titled defendant?
Yeah,
Now, Mr. Moore, I also have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Henry Dwight Moore, on or about October 8th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of a controlled substance, penalty group 2A, that had an amount less than or equal to 2 ounces. Do you understand what you've been charged with?
yeah,
And to this charge, Mr. Moore, how do you plead? Guilty, not guilty, or no contest?
guilty.
Are you pleading guilty because you're guilty? You just send this back to me. Never mind, I think I might be able to pull it back up. No, you have to unlock it. You did? It's not. Oh, what happened? Okay, now, Mr. Moore, I have before me a document that is titled Misdemeanor Plea Admonishment, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yeah,
On page 2 of the same document, there are 2 sets of initials. One set is on the line next to the box that's checked guilty, and the other is on a line that's next to a statement that reads, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty and no contest. You place your initials on this document.
yeah,
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
yeah,
And on the next document, there's titled trial court certification of defendant's right of appeal. Do you recognize this document?
yeah,
And is this your signature on the line that's titled defendant?
yeah,
At the top of this document, there's one box that's checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Now, Mr. Moore, before you signed and initialed all of these documents that I just showed, did you read the documents?
yes,
Did you understand what you read?
Yeah.
And is everything in these documents true and correct to the best of your knowledge?
yeah,
And Mr. Moore, are you a citizen of the United States?
yeah.
State, you like to offer State's Exhibit Number 1?
So offered, Your Honor.
Now, Mr. Moore, State would like to offer State's Exhibit Number 1. State's Exhibit Number 1 is the first document on the tablet that I showed you. It is the same document where your two initials are located on page 2, and your signature is located on page 3. Is it all right for the state to use this document as evidence in your case? Okay, now, Mr. Moore, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Mr. Moore, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. And I will also find that your plea and waivers were freely and voluntarily given. State, do we have a plea bargain agreement?
We do, Your Honor.
And what's that agreement?
The essential terms are as follows, Judge. It'd be 10 days, time served, time actually served. All court costs should be taxed and retired, and all conditions upon the plea, Judge. All bond conditions should be obviously set aside, Judge.
Okay,
Released from all bond conditions,
Yes.
given the completion of the sentence.
now, Mr. Moore, the state is offering that you serve 10 days in the Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail because you've already served 10 days in Jefferson County Jail. Therefore, you will be given credit for the time that you've already served. The court costs in this case will be taxed and retired. And that just simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. And you, because the case is being disposed of today, you will be released of any of you no longer be on bond. Okay. All right, stand at that table, follow the directions of the bailiff. Once you finish following other directions, you're free to go and you have a blessed day. What are we doing on Miss Marsh? You there, Miss Marsh? Well, we have, one thing I have is what, did anybody talk to her?
Who?
Oh, that's the one that's gonna be, I think they doing a restitution. Oh, they're gonna give her time. You gotta, I'll go ahead and do Mr. Branch. And then I'll get back with you. Cause hers is gonna be a reset, right?
Well, she's gonna go get the money order and bring it to us today.
Okay,
So we can address her, let her go.
okay, you come on up. It's once she's gonna get the restitution.
Once we do it, I'll do the dismissals.
Yeah, oh yeah, and he's 12:45. Why don't you come on up?
Wait a minute. Yeah,
Oh,
yeah, that is Branch.
Yeah, okay, Marsh. Okay, Miss Marsh. How you pronounce your first name? Nashia LaShawn Marsh.
Yes, sir.
How you doing, Miss Marsh?
I'm good.
That's good. Now, Miss Marsh, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document?
Yes, sir.
And is this your signature on the line? It's titled Defendant.
Yes,
Are
sir.
these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Yes.
I also have another document that's titled Waiver of Counsel for purposes of enter a guilty plea or proceeding to trial. And is this your signature on this document?
Yes.
Before you sign and initial these documents, did you read the documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, now, you talked to the prosecutor, is that correct?
Yes.
And y'all came to an agreement?
That's correct, Your Honor. The state has agreed to dismiss if Ms. Marsh pays the restitution. She's informed us that she would be able to do that this afternoon. She's going to go get a money order and bring that to our office. And
Okay.
once we receive that, we'll come to do the dismissal.
Okay, so Ms. Marsh, you've already talked to the prosecutors. He informed you that he told you what the amount and where you had to go. Once you make that payment of restitution to the district attorney's office, the state would submit a dismissal.
Okay,
Okay.
thank you, Judge, 'cause I really can't afford to lose my job
I
at
understand.
the prison.
Okay, I understand.
Thank you.
All right, you're welcome. Branch. Jeremiah Branch. Mr. Branch, your full name is Jeremiah Branch?
Yes, sir, I know that.
I'm doing fine. Mr. Branch, would you please raise your right hand? Mr. Branch, do you swear, affirm, tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
You may put your hand down. Now, how are you doing, Mr. Branch?
I'm doing fine.
That's good. Now, Mr. Branch, I have before me two documents. Well, first of all, we have three cases. Your cases are cause numbers 25 CCCR 2814 And the next case is cause number 25 CCCR 2815. And the last case is cause number 25 CCCR 2816. All three cases are styled the state of Texas versus Jeremiah Branch. And Mr. Branch, in cause number 25 CCCR 2814, I have before me a document that is titled information. This information was, well, first of all, before we go any further, Mr. Branch, you have a right to have a court reporter, which was sitting to my left, to dictate everything that's being said in court. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter? Or would you like a court reporter to dictate everything?
So
What's okay?
I waive it.
You waive it. Okay. Now, Mr. Branch, I have before me on my computer documents that's titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you like to waive your right to an attorney?
Yes.
I also have a document that is titled Waiver of Counsel for Purposes of Enter a Guilty Plea or Proceeding to Trial. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Branch, Mr. Branch, I also have on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jeremiah Branch, on or about September 14 of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft of property that had a value greater than or equal to $100 but less than $750. Do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, no contest?
Plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty? Mr. Branch, I also have before me a document that is titled Misdemeanor Plea Admonishments, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are two sets of initials. One set of initials on a line next to a box that's checked guilty. Are these your initials?
Yes, sir.
Second set of initials is on a line next to a statement that reads, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials in this location?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? At the top of this document, there's one box that's checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Mr. Branch, before you signed and initialed all the documents that I just showed you, did you read the documents? Did you read the documents?
Yeah,
Did you understand what you read?
yeah.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Mr. Branch, are you a citizen of the United States?
Yes, sir.
State, would you like to offer State's Exhibit Number 1?
So offered, Your Honor.
Mr. Branch, State is offering State's Exhibit Number 1 to be used as evidence against you in your case. State's Exhibit Number 1 is the first document that I showed you on this tab. It is the same document that have your initials in these two locations and your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
No objection, states exhibit number 1 will be admitted. Mr. Branch, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Mr. Branch, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. And I will also find that your plea and waivers were freely and voluntarily given. State, do we have a plea bargaining agreement?
Yes, we do, Your Honor.
And what is that agreement?
In order to ensure that justice is served, Your Honor, Mr. Branch will agree to plead guilty to 25 CCCR 2814 Class B theft, Your Honor. Received 135 days in jail, Judge. Time served, time actually served. In fact, Judge, he was held on all 3 matters for 135 days, and all court costs should be taxed and retired. In consideration of that, Your Honor, the state will dispose of criminal numbers 25 CCCR 2815 and 25 CCCR 2816 by way of 12.45 of the Code of Criminal Procedure. Further point out to the court, Judge, for the court's own edification, that this was one continuous spree over a 3-day period with the same victims like in the case, Judge.
Okay. Okay, now,
135 days.
okay, now, Mr. Branch, the state is offering that you serve 135 days in Jefferson County Jail, but you will not be required to serve any more time in the Jefferson County Jail because you've already served 135 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired, which means you will not have to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. And then the state will be dismissing cause numbers 25 CCCR 2815 and cause number 25 CCCR 2816 by virtue of the 1245 of the Texas Code of Criminal Procedure. Okay?
Yes, sir.
And so, Mr. Branch, do you understand the state's offer in this case?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay. I'll follow the plea bargaining agreement that you have entered into with the state. He has to sign this one too.
I'm sorry.
You will stand at the end of the table and follow the bailiff's directions.
You're lucky, Mr. Branch. You're welcome, sir.
What the let me tell you, it's now, Mr. Branch, if you do not have anything else holding you in jail, you should be getting out of jail today.
Yes, sir. Thank you.
You're welcome.
Yeah, I wouldn't.
Jefferson County Court at Law number 2 is back in session. The court is in session with 3 cases, cause numbers 25 CCCR 0774, cause number 25 CCCR 0776, and cause number 25 CCCR 2777. All 3 cases are style of state of Texas versus Brianna Marcel Jones. Ms. Jones, is that your full name?
Yes, sir.
Ms. Jones, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Ms. Jones, you may put your hand down. How are you doing, Ms. Jones?
Yes, sir. How are you?
I'm blessed as well. Thanks for asking. Ms. Jones, you're represented in your cases by your attorney, Martha Provo. Ms. Provo, how are you doing?
Doing fine, y'all.
That's good. Ms. Provo, do you waive a record in Ms. Jones' cases?
We do.
Ms. Jones, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Brianna Marcel Jones, on or about October 18th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense, theft of property that had a value greater than or equal to $750, but less than $2,500. Ms. Jones, do you understand what you have been charged with?
Yes, sir.
To this charge, Ms. Jones, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Jones, I also have before me on my computer tablet a document that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials BJ on a line next to a box. Let's check Nola Contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes,
Defendant?
sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Ms. Jones, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Jones, are you a citizen of the United States?
Yes, sir.
State over State's Exhibit 1.
Any objections?
No objection, no.
No objections. State's Exhibit Number 1 will be admitted. Ms. Provo, you have advised and counseled Ms. Jones. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Jones, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes, sir.
Ms. Jones, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 46 days county jail with credit for time served of 46 days. And that's that the court costs in this matter be taxed and retired. And the state agrees to dismiss the companion case 25 CCCR 2777.
And Ms. Jones, the state is offering that you serve 46 days in the Jefferson County Jail, but you will not be required to serve any more time in the Jefferson County Jail on this case because you've already served 46 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. There's no fine in this case. This case will run concurrent with cause number 25 CCCR 0774, and the state will dismiss cause number 25 CCCR 2777. Ms. Jones, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Ms. Jones, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Jones, we will move to your next case. Your next case is cause number 25 CCCR cause number 25 CCCR 0774. And in this case, I have before me the state's first amended motion to revoke unadjudicated probation. In this motion, it alleges that you, Brianna Marcel Jones, was tried in County Court at Law Number 2 of Jefferson County, Texas, on July 18, 2025, for the Class B misdemeanor offense of interfering with public duties. The court found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt. The court deferred adjudication of guilt and placed you on unadjudicated probation for a period of 1 year. In this motion, there are 8 allegations. State, are you abandoning allegations 2, 4, 5, 6, and 8?
That is correct, Your Honor. And we'd ask to go forward with allegations 1, 3, and 7.
Okay. Ms. Jones, the state is abandoning allegations 2, 4, 5, 6, and 8. They will be proceeding, however, on allegations 1, 3, and 7. Allegation number 1 alleges that you, Brianna Jones, or Brianna Marcel Jones, committed theft of property that had a value greater than or equal to $750, but less than $2,500 on or about October 18 of 2025 in Jefferson County, Texas, in violation of condition 1 of your probation order. Is that true or not true?
True.
Okay. Allegation number 3 alleges that you, Brianna Marcel Jones, failed to report to the Jefferson County Probation Office as ordered by the court on or about September 9 of 2025, September 23rd, 2025, October 9th, 2025, October 16th, 2025, as directed in violation of condition 4 of your probation offer. Is that true or not true?
True.
And allegation number 7 alleges that you, Brianna Marcel Jones, failed to pay court assessed fees as ordered by the court, and as of December 18, 2025, you were $80 in arrears in violation of condition 9 of your probation order. Is that true or not true?
True.
Are you pleading true to allegations 1, 3, and 7 freely and voluntarily?
Yes, sir.
And are you pleading true because they are true?
Yes, sir.
I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
There's one box checked on the front page. On the first page is MTRP, which means motion to revoke probation. On page 2 of this document, there's one box that's checked, and the box that's checked states that it's just true to allegations or motion to revoke probation, true to allegations 1, 3, and 7. And all these are initials BJ next to the allegations.
Yes, sir.
And is this your signature on page 3?
Yes, sir.
The next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
Is this your signature on?
Yes, sir.
And at the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, before you signed and initialed these documents, did your attorney, Ms. Provo, go over these documents with you?
Yes, sir.
And did you understand everything that she went over?
Yes, sir.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
State offer state exhibit 1.
No objection.
No objection. States exhibit number 1 will be admitted. And Ms. Jones, I will accept your plea of true to allegations 1, 3, and 7. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to revoke your unadjudicated probation, and your unadjudicated probation is hereby revoked. State, do we have a plea bargain agreement in Ms. Jones' case?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 48 days county jail with credit for time served of 48 days. We'd ask that the court costs in this matter be taxed and retired. And again, the state agrees to dismiss cause number 25 CCCR 2777.
Okay. Now, Ms. Jones, state is offering that you serve 48 days in the Jefferson County Jail, but you will not be required to serve any more time in the Jefferson County Jail in this case because you've already served 48 days in Jefferson County Jail. You do not have a fine, and the court costs in this case will be taxed and retired. This case will run concurrent with cause number 25 CCC Aura 2776, and the state will be dismissing cause number 25 CCCR 2777. Ms. Jones,
Yes,
do you understand the state's offer in this case?
yes, sir.
And do you think that it's fair and it's just?
Yes, sir.
Do you accept the state's offer?
Yes, sir.
Ms. Jones, I'll follow the plea bargain agreement that you have entered into with the state. Now, Ms. Jones, this will conclude your case. If you do not have anything else holding you in jail, you should be getting out of jail today. Now, Ms. Jones, how old are you, Ms. Jones?
20 years old, sir.
You're 20?
Yes, sir.
Guess what? I used to be 20. I was 20 for 365 days. And, you know, I know, Ms. Jones, you being a young person, you have friends. These days, y'all call them your BFFs, so you ride or die. And those are people that you would think will be with you when you're down and out, and they'll be with you through thick and thin. But on days like today, those people that you call your ride or die, your BFF is not here.
Yes, sir.
And I tell people this all the time, you know, in my day, we used to call him our ace boon coon. But I do see somebody that's here with you. In fact, you are the split image of that young lady back there. And you call that lady what? Mom?
Mama.
Mama. Okay? Mama, thanks for coming out here with your daughter. Now, you know, those friends that you thought would be here, they're not here because they had something better to do. But there was nothing in this world that could stop that lady from being here today. And those people that you call your friend, you know, they're not here.
Yes, sir.
No, everybody's not your friend, everybody's not your partner. But when that lady says she got you, she got you. Okay. And I know every now and then, well, I can say every now and then, that I'm sure that's the lady that put a roof over your head, put clothes on your back, food on the table. And every now and then I know she had to put a little spanking on your butt. And she did all of those things because she loved you. And that's why she's here today, because she loves you. And so before the sun go down on this day, you need to give that lady a big hug and a kiss for being here with you.
Yes, sir.
You're blessed. You said you're blessed, but you're blessed because you have somebody that loves you. Okay. Now, this is not the proudest day in her life to see you here in court. Okay. And you might think that, well, you're in a storm. But just remember this, when you're walking through a storm, hold your head high. Don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of a lark. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope and hope in your heart, and you'll never walk alone. There's one thing about hope. Hope floats. And so anytime that you're drowning in sea of confusion, just hang on to that hope, okay? And it'll keep your head above water,
Yes, sir.
okay? Now, some people might look at this as a stumbling block, but guess what? You could look at it as a stepping stone. And you know what? People use stepping stones to reach higher heights in life. I said that to say this. Anything that you want to accomplish, you still can accomplish those things, okay?
Yes, sir.
So don't let nobody tell you that your life is over, because it's not, okay? And so just hang on to that hope, okay? You know, there's one thing about work. Hard work works, okay? So just work hard, you'll be able to get there. And just, like I say, hang on and be appreciative for the mom that you have, because you are blessed. And mom, thanks for coming down here with your daughter. You know, I tell parents this all the time: hang on, don't hang up. Okay, we've all sinned and fallen short of the glory of God. But we serve a God, he's a God of another chance, not just a second chance, because God knows my second chance was over a long time ago. Okay, and so you'll be all right, but you're gonna have to change your behavior.
Yes, sir.
Okay, you gotta be patient, and you just need to make sure you get all of the help that you need. Okay, you got your mom here. God put her on this earth to be your mom, because she is the one who is going to train you up in the way that you should go. Okay,
Yes, sir.
okay. Where you been, where you going? Guess what? I've already been. She have already been. We looking through the rearview mirror. We trying to tell you what pitfalls to avoid. Okay, and so if there's not anything else holding you in jail, you'll be getting out of jail today.
Yes, sir.
All right, you have a blessed day.
Thank you so
Please,
much, Judge.
you're welcome. Stand next to the bailiff, and you can follow our directions. Thanks, Mom, for being here with her. You're welcome.
Maybe we can-
Yes, you may be excused, Ms. Provo. And
And,
she's checking on those prosecutors. Yeah, y'all excused too. I think she's checking to see whether or not And cause number 25 CCCR 2594 case is styled the state of Texas versus Levi Williams. Levi Williams was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Levi Williams at the courthouse door. Levi Williams did not answer. Levi Williams has not appeared in court since the court has been in session. The time now is 17 p.m. on today's date. Ms. Bailiff, would you please call the name of Levi Williams at the courthouse door?
Levi Williams, Levi Williams, no response.
Okay, Levi Williams' name was just called again at the courthouse door. Levi Williams did not answer. A reasonable time has passed to give Mr. Williams the opportunity to appear in court. State your motion.
State moves for bond forfeiture, Your Honor, and warrant to issue.
Okay, that motion will be granted. Levi Williams' bond will be forfeited. Warrant should be issued for his arrest in cause number 25 CCCR 2594. Next case is cause number 25 CCCR 2762. The case is South State of Texas versus Jalen Rashad Mayfield. Jalen Mayfield is scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Jalen Mayfield at the courthouse door. He did not answer. Would you please call? Well, I haven't marked as answer. Did he answer? So he marked as, okay, he did answer, but he apparently left because he's not in court, and when his name came up, he did not answer. Ms. Bailiff, would you please go in the hallway and call the name of Jalen Mayfield at the courthouse door?
Jalen Mayfield, Jalen Mayfield. No response, Your Honor.
Jalen Mayfield's name was just called again at the courthouse door. Jalen Mayfield did not answer. Reasonable time has passed to give Mr. Mayfield an opportunity to appear in court. He has not appeared in court. State your motion.
State moves for bond forfeiture, Your Honor, and warrant to issue.
That motion will be granted. Jalen Mayfield's bond will be forfeited and the warrant should be issued for his arrest. Cause number 25 CCCR 2762. Is that it? Right. This will conclude the calling of the court's initial appearance or announcement docket on today's date. February 3rd, 2026, Jefferson County, Texas, in County Court at Law number 2. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Prosecutors, you are excused. You're welcome.